all starts with a phone call. Someone under financial stress, possibly feeling a bit lost, finally decides to do something about it and calls a bankruptcy attorney for a consultation appointment. At some point after the consultation, the person decides to move forward with a Chapter 7 case and officially becomes the attorney's client by entering into a retainer agreement. Now the preparation begins. The client gathers and delivers to the attorney information the attorney needs to prepare the client's legal papers. Then the attorney has to have an opportunity to take that information and put together a first draft of the client's court papers, which will usually take the attorney less than a week. The client completes payment of the agreed-upon fees. Current bankruptcy law requires each Chapter 7 client to take 2 courses of financial counseling, and the first of these courses must be completed before the case is filed with the court. The client doesn't have to go anywhere to take the course. It can be done right over the phone. The client may be anxious about the counseling requirement, but it couldn't be easier. The client calls a toll-free number and speaks with a counselor, generally for an hour or less. The counselor then issues a certificate of counseling, which the attorney will file with the court. At this point, the attorney and the client have a meeting where they review the attorney's first draft of the court papers. Everything is checked, double-checked, and updated. When the attorney and the client are both satisfied that the final draft of the documents is accurate and complete, the documents are signed. The full package of documents often exceeds 50 pages. One of the documents the client signs is the petition, which looks like this. Now it's time to file the finished papers with the bankruptcy court. These days, everything is filed electronically through the court's secure computer system. All the client's information and documents are uploaded over the Internet. The court's computer responds by opening a new Chapter 7 bankruptcy case and assigning to the client a case number. This all takes place while the client is still in the attorney's office, and this is the exact moment the Chapter 7 case is filed. We now have our first milestone in the Chapter 7 case. As soon as the client has a case number, the client is eligible to take the second of the 2 required counseling courses. We like our clients to take the second course a few hours after the case is first filed, or at least in the first few days after filing, so we can get that requirement out of the way. The second course is called Debtor Education and can also be done over the phone or the Internet. Afterwards, the counselor issues a second certificate of completion, which the attorney must file with the court. About a week after the case is filed, the court sends a notice to all creditors in the case, as well as to the client and the client's attorney. The notice looks like this, and declares the Chapter 7 case has been filed and provides information about the case. Perhaps the most important thing on this notice is right here, where it schedules a meeting called the Meeting of Creditors. We now have our second milestone in the Chapter 7 case, and that is the date of the Meeting of Creditors, which will usually take place about a month after the case is filed. The Meeting of Creditors will be conducted and presided over by a trustee, who performs much like an assistant to the judge who's too busy to get involved in every single Chapter 7 case. The trustees are charged with reviewing the debtor's case, ensuring the paperwork is accurate, and gathering any property the debtor cannot exempt so that it can be divided amongst the creditors. At the creditors' meeting, the trustee will examine the debtor under oath regarding the papers filed with the court, but the trustees like to be prepared for that meeting. So, before the meeting, some trustees request the debtor to send in additional documents like deeds and bank statements. Some trustees like to talk with the debtor on the phone before the meeting of creditors to familiarize themselves with the debtor's circumstances before seeing them in person. In any event, debtors have a duty to cooperate with the trustee and comply with all reasonable requests for documents and information. The creditors' meeting itself is usually very brief. These are often scheduled for 6 cases every half hour, so it's not unusual for the debtor's questioning by the trustee to last no more than 5 minutes. And oddly, It's unusual for creditors to actually show up at the meeting, even though it's called the meeting of creditors. Once the creditors' meeting is concluded, from the debtor's point of view, the case goes into hibernation for 60 days. This is the period of time where creditors face deadlines for making any objections. The 60-day deadline relates to creditors making objections regarding the debtor's discharge. There is a shorter 30-day deadline for objections to the debtor's claims of exempt property. Since neither of these objections is common, the 60-day period following the meeting of creditors is mostly just waiting for time to go by, with no active involvement by the debtor. The important thing is that the judge must wait until the 60-day period has run to see if any creditor files an objection. If none are made, and that is usually the case, the court will grant a discharge shortly thereafter, usually in the next few days. In most cases, the total time from the filing of the case to the entry of the discharge is about 3.5 months. The discharge is the document that the entire Chapter 7 has been working toward. It is the official forgiveness of all the debtor's dischargeable debts. That is, it discharges the debtor of all legal obligations to repay those debts. The discharge is the fresh start. If you're under stress from finances, then maybe it's your turn to pick up the phone. Give us a call and schedule your consultation.